We are doing tonight's Instagram Live with someone who's been on here a few times before. Her name is Stephanie, and she is a domestic violence attorney who has changed a bit over to be an attorney for the child. And she's from New York. Let me see if she's here yet. Stephanie and I connected a while ago over TikTok, which is funny, but I actually got to meet her in real life because she was part of, let me see if I could find her. I don't know if she's on yet. She was part of there she is, family law conference that happened last. Celebrity who's really good at her job, and we had, done these interviews virtually, and then we got to meet in person. And here you are. So haven't seen you in a while, Steph.
No, it has been a long time.
I know. Oh, I know. So it's so good to see you. You look the same. And I was just saying that we got to meet in real life, which was so cool. I think you were like one of the first people that I met through social media that I got to meet in real life.
You were my first.
Yeah. And it was great. And we got to spend a little time together. So I'm going to ask you about your background instead of just telling people. So tell us about your background for people who don't know you. And if you don't know Stephanie, you should follow her on Instagram, but especially on TikTok, because you're like huge with tons of content there.
Thank you. So I'm currently an attorney in New York State representing children, mostly in family court. Before that, I was in family court representing domestic violence victims. I did that for many years for various nonprofit organizations throughout the state of New York. And that was really the primary focus for the majority of my legal career.
Yeah. And so now you're an AFC, attorney for the child. What made you decide to become an attorney for the child?
So when I was in law school, I really wanted to do juvenile criminal representation. So I always had an interest in representing children. But from the very beginning of being a family law attorney representing parents, I experienced the frustration that I think a lot of parents experience, and you and I both get in our comment sections, which is being on cases where the attorneys representing the children were not, to put it frankly, not doing a good job. I had so many cases where they showed up to court having never met their client. I had no idea what their client's position was. I had people not know who their client was living with, how old their client was, really basic information that someone should know. And I just got really, really frustrated over the years of seeing these kids' voices not being heard. And as much as I loved representing domestic violence victims, which I did for so many years, adults get to go to court appearances. Even if they're not represented, they get to be there and they get to speak for themselves. And if the attorney for the child isn't there doing that, children don't get that option. And so it got to the point where I wanted to do something about it. And I was so lucky that a position with an agency in the region I was practicing in became available, and I jumped on it.
Yeah, well, I'm sure everybody is really lucky to have someone like you doing this kind of work. Can you first explain what is the difference between an AFC and a GAL and minors counsel? Because I think people think it's the same thing, and it's not.
It's not. So there are so many different names. You just said a few of them. It can also be a law guardian. The primary difference is one's an attorney and one is not. In some places, and you usually don't have both. I'll start with that. People tend to think there can be a GAL and an AFC, and it's usually one or the other. So in a state where you have guardian ad litems appointed to children, they are guardians. They're not attorneys. It could be anyone. It doesn't have to be someone with a law degree. It could be someone with a social work degree, someone who was a teacher, someone who was in a religious position. They represent the child in that their main goal, their outcome, is to decide what they think is best for the children and advocate for that in court. My job is not to decide what's best for my client. My job is to advocate for what my client wants. So it's just like a parent's attorney. A parent goes to an attorney and says, here's the outcome I want, and I want you to make it happen. That's my job too. Another big difference is that I have confidentiality with my clients who are children in the way that GALs don't. A guardian ad litem doesn't have a duty to keep their contact confidential because they're not an attorney. So anything that child shares with them, they can then share with the parents and with the court. And I can't do that. I need consent from my client to disclose anything that they tell me. And I think that makes children a lot more comfortable. They can disclose things to me that I'm not going to tell their parents. And that's a conversation I have with every client. And then I would say the other big difference is I can't be called to testify about my client because we have that confidential relationship. And I
Really?
in a lot of states, a guardian ad litem, they're treated kind of like a custody evaluator. And so they can be asked to testify in a custody case. And they really investigate. They talk to everyone involved to get a holistic picture because their job is that. I can talk to both parents, I can talk to other involved parties, but the only person I'm required to talk to is my client.
Wow. Okay. So first I was thinking, since the child is your client, is there an age limit? Like you can't have a baby be your client because a baby can't talk, right? How does that work?
I have had a baby as my client. It really varies by judge. It varies by region. I mean, even in New York, it trends a little differently. There are parts of New York State where they won't appoint an AFC to a baby. It used to be in some courts that they would appoint an AFC on every single case, no matter what. Because we're so overloaded with cases, because there's so many cases in family court, I will say I have seen that the trend is to kind of back off of that and start assigning us more in kids like 5 and up. Mm-hmm. But if you have a child who is too young to speak to you, which happens, it has happened to me, you then have to default to that what is in the best interests of the child because you can't advocate a position. And so I have had to do that. And that's a situation where I would talk to both parents and talk to, the babysitter or the preschool teacher or whomever I can to get as much information as possible. And then I have to do a best interests situation because I don't have a position.
Yeah. Wow. And so I was going to say that one comment that both of us get all the time and is a huge issue in this community is there's a balance between like, I want the child's voice to be heard, but what if the child is lying? Let's get into that.
As a DV attorney, had so many cases where a child is being coached by a parent. I'm sure you've talked to many, many people who've been through that. And I was actually that was something I was really worried about when I transitioned to being an AFC, that I wouldn't be able to catch it. And it's been my experience that it is much more obvious when a child is lying than when an adult is lying. And I mean, I'm lucky that I received training in this, and I can't say that every AFC does, but there are different ways we handle it. If a parent tells me a child is lying, I'm of course not always going to assume that that's automatically true, because certainly there are parents whose kids allege domestic violence who say, well, of course that's a lie and I never hurt my child. And so first and foremost, I will say, and this can frustrate people, it is my job to believe what my client tells me. Just like when I represented victim parents, it was my job to believe what my client tells me. Does that mean I'm going to assume everything that a 5-year-old says is true? No, I'm going to ask them questions to get to the root of what we're talking about. It's common for a child to say, I don't want to live with my dad, and then when you say why, they can't tell you. They don't have an answer. And so if I ask follow-up questions, they will give me information that contradicts what their ultimate position is. That's an example. I mean, we get a lot of kids who you can tell they're lying because they happen to be saying the exact same sentences that are in their parents' petitions in the exact way that they're written in those petitions, And so there actually is case law that says if you have reason to believe, it can't just be I think, it needs to be some kind of proof I have to believe that my client has been coached or my client is lying to me. I then have to substitute judgment, which is where I advocate for what I think is the right outcome for this child. So I'm not going to take them at their word immediately. I'm going to meet with my client multiple times, just like I would if I were representing adults, until I feel that I have a holistic view of what's going on. And if I truly think that they are being told to lie to me, then I have to substitute judgment. I have to advocate for what's best for them because that's what the law requires me to do.
Yeah, and so we just got a question, which is tricky. What if the child is telling you something that they want, but you know it's not in their own best interest?
The law says that I have to advocate for what my client wants. And it's the same, again, what I love about this job is it's the same as representing adults. The children get the same rights. If I had a client come to me who, I think I said this in a TikTok video recently, like if I have a client come to me who abused their child and wants sole custody, my job is to advise them that I don't think that's going to happen. But if that's what they want, I have to advocate for it. That's what the ethical rules that all attorneys are bound by require us to do. I don't have a say. It's not my decision. It's not my choice. It's not my life. So if my client says, I want to live with parent A, but parent A has a history of abuse, or parent A doesn't have a bed for their child, I will counsel them. I will discuss why that is. I will discuss how they feel about the other parent. Do you think there's a compromise here? Do you feel safe there? Do you feel comfortable there? Do you feel that you will be able to sleep well and get your homework done? I'll counsel them through it if I feel conflicted about what they want. But at the end of the day, again, it's not my choice. It's not my life. And my job is to advocate for what they want. And I think that's really important, that someone actually care about what they have to say.
Yeah. Now I'm thinking too, if a lot of states tend to, with judges, or at least we hear that they tend to generally move towards 50-50, what can an AFC do to impact that?
Do you mean to sort of go against the 50-50
Yeah,
people?
yeah. Like say there's an issue with one, domestic violence is taking place. Judges generally think 50-50 is the norm. What can you do in your position to advocate for your client as to say this is completely like how much an impact can you have?
So one thing I will say is, and I would say this to clients when I represented parents, AFCs have a lot of power. And I knew that then, I know it now being in the position. I do think the judges give a lot of weight to what we have to say. And, I don't take that power lightly. And I think that's really where the strength of the advocacy comes into play. Because if you're in front of a judge who prefers a 50-50 default, even in a state where that's not on the books, like New York State, I've had it happen many times, that's where the strength of the advocacy comes in. And it really is on the attorney, the advocate, to explain to the judge why that's not appropriate. I'm very lucky that where I work right now, I have attorneys who, I'm a litigation attorney. I do a lot of in the courtroom talking, litigating work, but I also have attorneys who focus on writing. And so I will additionally work with them to put motions together. And there's so much case law in New York State and other states that explains why a 50-50 default is harmful and why a 50-50 default is not in the best interests of the child, and why there are other parenting schedules that are better based on a million different factors. And so it comes down to oral advocacy and written advocacy. It's really fighting the fight for the client. And like I said, that was something I didn't see a lot of before. And I really felt that children needed that strong advocacy.
There's a lot of fear regarding a GAL, a guardian ad litem, when it comes to custody evaluation, but an AFC, an attorney for the child, in my own experience, I found an AFC extremely helpful for my daughter, who was a little older at the time that we had this particular issue. But I was shocked at how much she advocated for my daughter, and the judge completely went along with it. And it was such a relief, because I don't know what her training was, but she was so warm, and she seemed to very caring and very easy to talk to. And she immediately connected with my daughter, and I felt like this is somebody who basically helped save my daughter's life on a certain level emotionally, because of the care that she put into it. And when we did our book, she was in our acknowledgments. I'll never forget that level of care. And another thing that shocked me was that she was appointed by the court, and the court paid for it. how common is that for because guardian ad litem, we have clients spending thousands and thousands of dollars and then even more when the report has to come out, but I didn't have to do anything.
Yeah, it is. You know, in New York State, we are appointed. I know that there are counties in New York where maybe there are not enough AFCs, or an AFC was denied and had to be privately hired, but we are appointed in the court by New York State, and we are paid. We're paid by the state, and that doesn't happen everywhere. And I agree with you. I think it's wild that it falls to the parents to be able to afford representation for their children, because again, children should have the same rights that adults do, and I think it's completely unfair that a child doesn't get that advocacy unless their parents can pay for them to have that advocacy.
Yeah, yeah. Okay, so we're getting a question which I think you sort of answered, but let's see what you have to say. There's a situation where the child of an alienated, healthy parent doesn't want to live with the parent. At what point do you start disagreeing with your client, the child?
Yeah, so I can't disagree with my client. No attorney can disagree with their client. I mean, I can tell my client, I'll rephrase that. I can tell my client that I disagree with their decision. If they're an adult, I'm going to say that. If it's a child, I'm going to say it a little differently. But, you know, my job is advise, but support. So I can advise why I think that's the wrong decision, what other things I think should be considered, child or adult. But at the end of the day, the attorney's job is to advocate for your client's position, whether you agree with it or not. So there is no point at which I advocate for anything different than what my client requests in court, unless, of course, I have like verifiable proof that they have been coached to say something, or they are so brainwashed that they are beyond the ability of forming an opinion. Or I've had situations where I had one recently where one parent would not stop discussing the case with the child and would not stop making the child feel guilty for choosing one parent over the other, to the point that the child was no longer comfortable having her opinion shared in court because she just knew it was going to come back to her. And I had to go to court and say, look, if you're going to keep pushing your child to the point where she can't disclose her position anymore, I'm going to have to choose one for her.
Yeah, yeah. I mean, I'm sure that's resonating with a lot of people here. So speaking of that, I know, and this just came up with one of our clients where it was a GAL, but I said I would ask you about it because I said this makes me think of a similar issue where the let's say an AFC is talking to their client, but the parent wants to tell you what the child really thinks and to make sure to ask the child these questions because they're not going to just say it to you. How do you deal with the parents that keep wanting to talk to you or feel like this significant thing happened and you need to know about it, so I'm going to tell you?
It's unfortunate because it's a really like boy who cried wolf situation, and then I've had so many parents who don't have their kids' best interests at heart, who are trying to manipulate the situation, who will come to me first to try and tell me. I mean, I recently had a parent, and thankfully all of the truth came out and this issue was resolved, but I had a parent try to preempt my meeting the child by saying you shouldn't believe anything that he says to you because it's all going to be lies. And
Wow.
turned out to be a very concerning situation. I was thankfully able to help my client get out of that situation, but it happens so often that it's almost at the point where I am developing this preconceived notion that I shouldn't believe anything that's said to me until I've spoken to my client. And I do still think that my priority needs to be to them. So what I will say is my job is to listen to my client and advocate based on what they tell me. If a parent says to me, I have a concern about, I can certainly ask my client about it, but I cannot be told what to discuss with them. I cannot be told how to discuss it with them. It is incredibly common for parents to say in court to the judge, well, I want the AFC to ask my kid about this, or I don't want the AFC to ask my kid about this. And every time the judges say, one, the AFC is not an investigator. It is not their job to find out information for you. Two, they don't work for you. They're trained in talking to children, and they're going to talk to their client in the way that they feel appropriate. So this is why always go back to, it's so important to put your concerns in your petitions that you file in court, because that's what gives me the basis for what I'm going to talk to my client about. If you have a concern and you don't put it in there, I'm not necessarily going to even get the opportunity to speak to you before I talk to my client. And so if there is something that you as a parent feel needs to be addressed, it has to be in there. I don't know if I answered your question, but it's not my job, nor am I required to speak to any parents about the issues. My duty, my ethical obligations are to my client.
Okay, so something that I had put up, one of your posts that you did, I wrote in the caption that people need to watch this interview because they don't want to be that parent. What are things that parents do that are irritating to you or that they really should not be doing?
I mean, the number one irritating thing is when they don't want us to talk to their children, because it's one thing to say, I don't understand the process and I would really appreciate that being explained. I get that. Court is confusing. It's not explained to you. I'm happy to explain who I am and what my role is and why I'm talking to your child. But it's really common for us to get parents who say, my kid doesn't need a lawyer, or I'm capable of speaking on their behalf. No one else needs to do it. Or you're a stranger and I don't trust you talking to my child. I get that a lot. I've seen it in both of our comments. And maybe this is misplaced, but a lot of times I hear, I don't think my child deserves the same rights that I do.
Wow.
And I get it. Here, but you didn't know your attorney before you started working with them. They were a stranger to you. Everyone your child's going to meet is going to be a stranger, but I'm not just any stranger. I'm someone who's trained in working with children and whose sole job is to make sure that your child is safe and happy and comfortable with where they are. So I would say the most frustrating thing is people who don't want us to talk to their kids. Because the other thing is, I'm court ordered. It's not up to me or you as a parent if I meet with your child. I've been ordered by the court to do it, and that's going to happen whether either of us want it to.
Yeah, and again, it makes me think of the irony that so many people are going on about how can my child's voice be heard in court? You're the perfect way for a child's voice to be heard in court, and yet you're saying you get so often people saying, I don't want my kid talking to you. It's almost like I want my child's voice to be heard, but it has to be what I want them to say, or they have to agree with me. Otherwise, no, then this isn't going to work.
And I don't think people realize, I don't think they realize that they don't get to speak on behalf of their child. I had a parent's attorney today in court try to say, well, the child wants, and the judge stopped them and said, no. If the child wants something, their attorney will tell me that. And a lot of times judges won't even let the parent or the parent's attorney talk about the child's wishes because it's not their job. And I recently had a parent who did not want their child to meet with an attorney. We'd been to court over that exact issue, who said to me, what happens if I don't bring her? And I said, well, unfortunately, what happens is your child's voice doesn't get heard in court.
Yeah. What percentage of the cases do you think are assigned AFCs, or are there certain types of cases that usually get assigned an AFC?
So in my experience, if it's a custody case if it's a custody or a family offense case where the child is included, any child who can communicate is going to get appointed an attorney. Usually where I have practiced for many parts of New York, and that usually happens pretty early on, judges kind of default to that. And I really think judges don't want to be solely responsible for making the hard decisions. And that's why they have AFCs, because they really want someone else to help them make that choice.
Yeah. Now, back to, so you've been extensively trained in DV, domestic violence, but also in working with children. Are there ways that you are able to get kids to open up to you, to establish a rapport? Because, often kids in the situations that we see, there is coercive control going on. They are afraid to speak up. Like, what would make a child begin to open up? I mean, I remember speaking to a lawyer in California who was minors counsel. He said one thing, he's a really big guy, and he said he'd get on the floor with them all the time. So are there things that help you establish a rapport? Because like with anybody, kids have to be comfortable before they can talk.
Absolutely. And I think that rapport, one, comes from creating a relationship which isn't going to happen after one meeting. So if I have a child who doesn't open up to me, I'll ask the court for more time and I'll say, I need to get to a place where this child is more comfortable talking to me. But I think the setting is really important. So age dependent, because I can meet with them on Zoom. If they're more comfortable being in their bedroom on a computer, I'll have them come in my office if I have concerns that we're not being given privacy at home. And then there are different settings there. I can take them into a playroom. I can take them I do a lot of coloring with kids. Playing with toys, I think just creating a comfortable space for them to be in. Another thing, if they're really young, is something we do a lot is bring the parent in with us so they can see their parent be comfortable in this space. So they know, okay, my dad came in here and he was fine. I guess I'm okay in here. Before, of course, having the parent step out because I have to have a confidential meeting. But I think setting is really important. And I think the other thing that makes them feel comfortable is I explain confidentiality. And obviously, I'm not using that big word with all of my clients, depending on their age. But that's one of the first things I start with. Before we even talk, before I'm even asking them questions, I want them to know that I'm not going to go and tell mom and dad what they're saying to me.
Mm-hmm.
So I think it's one, creating a physical space that they feel comfortable in, and then two, verbally assuring them that I'm a safe person to talk to.
Yeah. We just got a question. I can't wait to hear what you say to this. Are you allowed to ask your client if one of their parents disparages the other parent? If so, do you ask this frequently?
Absolutely. I think two of the most common issues we deal with in custody cases with children is one, are the parents disparaging each other, and two, are the parents talking about the case to the kids. And it is incredibly common, I would say, in almost every single one of my cases, we actually have in the court order that parents cannot disparage each other to the child and they cannot discuss the case with the child. And absolutely, I ask it. I don't ask it like that. I have numerous other ways that I bring up that information. But that's something I want to know, because obviously my client's opinion of their parents is going to be swayed based on what they're saying about each other, and the parents shouldn't be doing that. And I want to know if the case is being discussed with them, because no one should be telling them what's going on in court except for myself. So yes, I ask those questions.
Okay, so let's say you discover, because in our world this happens all the time, that one parent is disparaging the other parent and talking about the case, and the kid is really stressed about the case. How does that impact how you deal, what you say to the judge about that?
If I have consent, because of course I need my client's consent to talk about what we discuss, I tell the judge, I say, my child told me that mom said this about dad the other day, or dad said this about mom. If I have consent, I can bring up whatever I want. And sometimes the easiest way to get it addressed by the court is to just repeat exactly what was told to me. And again, like I said, AFCs have a lot of power and judges give what we say a lot of weight. And so really anytime I bring up to a judge that my client is saying that, I then immediately get a court order, as well as a discussion on the record about why that needs to stop.
Yeah, I mean, we often talk about custody factors with our clients in terms of how they can start building up a narrative to present what they're doing with their case, with their lawyer, or if they're pro se. But we know one of the top custody factors is one parent attempting to undermine that other parent's relationship, and there's so many ways that happens. And so I would hope that a judge would pay attention to that when considering custody decisions.
They do, and I think especially when it comes from the AFC, because obviously both parents' attorneys are arguing against the other parent. And I think, and this is why I used to advise my clients when I represented parents, make sure obviously don't tell them what to say to their attorney, but encourage your child to be honest with the attorney, because you saying, my daughter said that dad told her this, doesn't really the weight that me as the AFC speaking on behalf of the child has when I say to the judge, dad told daughter this.
Yeah. Now, what is like one of the most difficult things about your job, or what's something that you can't stand about your job?
A really hard one is when you have kids who don't agree with each other. And that actually,
Oh, the same family, you mean?
yeah,
Oh,
and
interesting.
conflict of interest, and I cannot represent two children who have differing opinions. So if I have a basic custody case and one kid wants to live with mom and one kid wants to live with dad, I cannot represent both of those children because obviously I can't put on a trial that supports both parents
Mhm.
what they want. And so that can be really difficult when you have two kids who are split between each other and don't want the same things. And you then, and then I have to go and tell one of them, I might not be your attorney anymore.
And do you see cases where parenting plans really, or how common is it for parenting plan to be different for different kids in the same family?
It is not common. I will say that. I think it's on my mind because it happened to me today. It's not that common. I think more so we see it. I see it a lot when there's a big age gap between the kids, especially TV history. The 13-year-old is going to remember that a lot more than the 4-year-old or the 5-year-old is.
That makes
I
sense.
had a 5-year-old who says, I'm totally happy with both parents because they only have good memories of both parents. And the 5-year-old says, well, I don't even want to see this other parent because I remember years of violence in our home. And that can be really difficult when it's like, that younger child may not be safe in that person's home, but you can't actually report that on their behalf because they have no memory of it.
Yeah, wow. What are some misconceptions about what an AFC can do and can't do?
I think, well, first and foremost, people confuse us with CPS. I don't
Oh,
have the
really?
authority to order that a child be removed from a home. I have the authority to file a motion with the court requesting that a judge order that happen, but I don't have the authority to tell a parent, you're not seeing your kid today. And I will have a lot of parents who say, my kid came home and said that their other parent abused them. Do I have your permission not to take them to visitation that week and next week? And I don't have the authority to say that. Even if my client said, yeah, my parent abused me, I'm not a judge and I'm not the government. I'm not CPS. I don't get to say, okay, don't bring your child to visitation.
Yeah. I was going to say, yeah, I can imagine. I can imagine like all the things that people tell you. But are there things that often people are like, you should be able to do this, and you have to keep reminding them of the same thing, like I can't, or this is what I actually do, not that. Like I remember once I interviewed a custody evaluator, and he said one of the misconceptions people think is like they're here for therapy. Like that's not my job. Like my job is to deal with their child, but they think that I'm supposed to deal with their issues. Do you notice that also?
Parents, really, I actually had this conversation with coworkers recently. It's common for parents to think that my job is to advocate for issues that they bring to me or for their position. So, if I have a child who says, I want to live with mom, mom then may think that it is my job to argue all of the issues that mom thinks are necessary to argue.
Mhm.
They kind of see it as if I represent the child and the child is aligned with them, I also represent them, and that's not the case. And so I actually had a coworker recently kind of get screamed at by a parent because she wasn't arguing the things that that parent wanted her to argue in court. And the fact of the matter is, my job is to argue what my client brings to me. And if you have an issue that you want to discuss, but when I discussed it with my client, they didn't have a position on it, I can't then take a position just because that child wants to live with you and you have a position on it,
Mhm.
which can be really confusing and really frustrating. So it's very common for us to have parents who are frustrated by, well, why didn't you
Mhm.
side with me? Or why didn't you make this more of an issue in court? So I think it's really important for a parent to understand that just because my client, the child, is aligned with them does not mean I then become their advocate. Certainly, I'm going to argue facts that help them, but that's not the same thing.
Yeah, yeah. I'm so glad you're saying this and that people are going to be able to hear this because I think it's going to clear up some things, even though they're not going to like hearing that.
Yeah, another one, I just recorded a video on this. I haven't posted it yet. Is I also have to tell parents I'm an attorney, but I'm not your attorney, and I don't have confidentiality with you. And so I could start a case and my client tell me I want to live with mom. And so at that point in time, I'm aligned with mom. But then if mom tells me a bunch of really personal information, and at a later point, my client changes their mind and I'm now aligned with dad, none of that was confidential. And anything that they told me, I can use in court. So I also think it's really
Really? Oh
absolutely,
boy.
absolutely,
Okay.
because I owe them a duty of confidentiality. So another thing I'm constantly reminding parents of is be careful what you say to the AFC. I actually, and this is why I have to get permission to speak to parents if they have attorneys, because you can so easily derail your case by sharing a piece of information with an attorney that's not yours. And just because I'm aligned with you in that moment does not mean I'm your representative, and does not mean that I can't at any point use a certain piece of information against you. So parents really also need to consider that I'm acting in my client's interests, not theirs.
It makes me think of getting arrested and having your Miranda rights read to you, like know that anything you say could and
Mm-hmm.
might be used against you. So careful. Wow.
Yeah,
Interesting.
that's something that really makes people unhappy. And I will say up front, like you need to really think about what you say to me, and you should ask your attorney if it's okay before you do it.
Wow. Such important information. I mean, thank you so much for that alone, Stephanie. Like, you don't want to harm yourself. Okay, so one of the big things that comes up all the time, and which we touched on a little bit, is abuse by proxy slash parental alienation, which a lot of our viewers, they don't know that, you know, the connotations that come with that. But basically, it's the idea that one parent is attempting to turn the child against the other parent. And they'll say, like, this is happening, and if the kid is showing signs of that, what what can a parent do, or is this just beyond the scope of what the courts can handle?
You know, it really, unfortunately, and this is the answer to every question, is it's so dependent upon the facts of that case. I think it's really important to discuss with the AFC what resources there are. I actually recently had a client who it was one who was word for word mimicking her parents' petition, and she was far too young to be using some of those words. So to me, it was very obvious that they had been taught what to say to me. And I ended up referring her to a social worker to meet with a social worker who worked with her in a little bit more depth to figure out where those statements were coming from, and kind of get to the bottom of what her real feelings were and not the
Mhm.
feelings she's been able to say to me. I've referred children to therapy. I'll do all kinds of different meetings with them. You know, if a parent says to me, I'm concerned that when you interviewed them in parent A's home, they weren't saying how they really felt because parent A was there.
Mhm.
I'll say, let me meet with them in your home next. How about you bring them to my office and I'll meet with them privately? How about a grandparent brings them to my office and none of you are there? It's a mixture of figuring out what resources are helpful for them, and also, unfortunately, yeah, it's also on the AFC to actually care about and devote the time to getting to the bottom of those issues with the children. And that's why AFC advocacy is so important. Having people trained in doing this work is so important, um, which would be a lot easier and more accessible if we had more state funding for that. But that's a separate issue. But
Yeah.
say talk with their attorney, talk with the attorney for the child to figure out what kind of things can be done to get to the root of what that child's being told.
So because, I mean, if you can't answer this, it's fine, but because this is such a huge issue in this community, so not just for the child, but many of our people, their kids have been turned against them and they are just devastated.
Mm-hmm.
Do you know of any resources for parents who are feeling so completely alone, like, oh my gosh, my kid doesn't want to talk to me, or my kid doesn't want to live with me, and they're the victim parent?
Yeah, I mean, I had, and this is not something that every judge is going to do, so it really depends on the judge, but I had a case like that today where an older child had really ultimately did not want any contact with that parent, and the court ordered therapeutic visits. I think parents are really hesitant to do any kind of supervised therapeutic visit because it feels like a punishment. And I get
Mhm.
because when your child is living with you and now all of a sudden 3 years later you're being ordered to meet them with a social worker, it does feel like a punishment. It feels unfair, and a lot of times it is unfair. Um, but I can't change what's happened in the past, neither can they. And I think this feels so like gaslighty to tell victims, but like patience is key. You shouldn't have to be patient, but if your kid has been brought to that point, it's okay to say, fine, I'll do a therapeutic visit. Fine, I'll do a supervised visit. I'll do a social worker visit. Because if you get good reports back from that social worker, that psychologist, whomever it was, that goes such a long way in court. If you have a social worker who can put into a report how well that visit went. And so I hate telling DV victims and people who have had their kids turn against them, that you should just suck it up and do that agency visit because they shouldn't have to, but it really can go a long way.
Okay, and now a question for the flip side, which we know happens. How about false allegations of alienation? We know often in abuse cases, the whole parental alienation card is played to try to distract from the abuse. It said that can cause a lot of harm as well.
So that is something that came up in one of my cases today. I had a client who was saying that their child had been turned against them, but I had a really long, in-depth person-to-person meeting with this child who I did a lot of work to get him to feel comfortable with me. We got to a point where we had a really detailed conversation, and I learned that all of those allegations were false, and this kid was so frustrated that those allegations were being made. And this goes back to why it's so important to have AFCs, because you can have a parent who has, a really strong attorney and submitted really strong petitions, and by all means, when you look at the record, all of those allegations are true. But I'll go back to judges give a lot of weight to AFCs. And so if I come to court and I say, actually, here's what my client told me, and here's all the information I have to back that up, and here's why I have every reason to believe that none of those allegations are true, that changes everything. And so it's hard to ask judges for things, but I would really encourage parents in cases where there aren't AFCs to advocate as much as they possibly can for the court to appoint one. Because I know in some places it's automatic, but in some places it's not, and judges don't really want to do that if they don't have to. So it's important to ask for one and really push for that.
Yeah, it's like get a professional involved who really understands and has a lot of experience with this and can have your child's voice heard.
Yeah, and I think attorneys get a lot more permission to speak. I mean, just to put it like that, I'm allowed to say a lot more to a judge than anyone else could, than a school counselor or a teacher or whomever could speak on that child's behalf. So while there are a dozen other people who could do that job, not to like toot attorneys' horns, but we matter a lot more to the judge.
Yeah. All right. Someone just asked, and I don't know if you know, Stephanie, because you're New York, how do we find out if Florida designates one? I have a PC and a GAL, and someone also asked what's an AFC because they came in late. It's an attorney for the child.
Honestly, this is going to sound ridiculous, but Google it.
Yeah.
I mean, the language is, so Florida, actually, I should know the answer to this. I don't think Florida has AFCs because my boss that I currently work under used to practice in Florida. Florida, however, is a very different legal system because they have their own juvenile courts for all types of juvenile issues. It's also its own section on the bar exam, which most states don't do. So, but Google it. I mean, the difference really comes down to whether they are a lawyer or a guardian. That is what changes those roles completely. So those are the like buzzwords you want to look for. If people who represent children in family court are lawyers or if they are guardians. If they're a lawyer, they're everything that I've talked about thus far.
Yeah. So in terms of getting an AFC, I know often when someone's looking for a GAL or a therapist or whatever, they can come up with a list of 3 and then the other person picks one. So, but is it ever possible to request a certain AFC, or no, it's purely or generally appointed by the judge?
If, speaking to New York, if this is a case that existed in the family court system before, so you got a custody case 4 years ago and it's been reopened, and you want to have the same attorney you had the last time, it's incredibly likely that you'll get that same attorney, because judges don't like attorneys having to relearn a case if they don't have to. More often than not, though, you do not have a say in who is assigned. Just like if you get assigned counsel from the court, unless you had someone previously, you don't really get a say because it's totally up to resources. Where I practice, they don't even appoint us individually, they appoint our agency, and then procedurally it gets sent to managers, and managers decide who to assign the cases to. So more often than not, you really don't have a say. But if you have a prior relationship with someone because they have some kind of prior experience on that case, it's far more likely that you could get that person reappointed.
Oh, yeah, that's a great idea. It makes sense. Okay, I see another question. A lot of times children side with the abusive parents and say they don't want anything that was discussed with you to be disclosed in court because they're scared of their parent. What do you then do so the client doesn't give permission?
It happens a lot that kids are, whether it's scared because they have an abusive parent or there aren't abusive parents, they just don't want to make either of their parents feel bad. It's very common for us to get children who don't want us to disclose their positions. And that is something that takes time. And usually I will go to court and say, I don't have consent to share my client's position right now, but I'm really hoping that we can get to a point where I can do that, and I'd like more time. And for me, it's a matter of working on my relationship with them and also counseling them about what's going on. So if they're old enough to comprehend, I will have a conversation about how, no one's going to know how you feel, and how you feel isn't going to be considered when the judge makes their choice. So if you don't give me permission to share this, no one's going to know that it's what you want. The other option, and we really don't like doing this because it's a really difficult thing for children to go through, but there are things in most states called Lincoln hearings, which is where a judge talks to just the child and the parents are not present. And I've had to in some cases where I feel that the court is leaning towards something that my client doesn't want because they haven't heard my client's position, because my client doesn't want their parents to hear it for whatever reason. I have to request a Lincoln hearing, which is where the child and myself meet with the judge without the parents. And the judge.
Okay, so it's not the child alone, it's with you and the judge.
Me and the judge, nobody else. So I said, well, look, if we can talk to the judge, but mom and dad aren't there, would you be okay with that? And again, it's tough to have to put a child in front of they usually don't sit on a witness stand in a courtroom. It's usually in chambers or a more comfortable space. But, it's not easy to have a kid have to go tell another total stranger about these intricate details of their life. But that is an option that we have as AFCs. And usually it's up to me to request it, not either parent's attorney. Sometimes parents' attorneys do request it. They say, well, I want the judge to do a hearing with the child. And if I don't want it, I can object. And more often than not, they're going to side with me. But that is an option. If my client doesn't want their parents to hear, that is something that I can request. However, that usually happens much closer to trial. So if you're having multiple appearances leading up, that hasn't happened yet. And that's where me counseling them into letting me reveal certain things comes into play. And a lot of times I'll say, well, what can I share? Or I'll give them hypotheticals. If the judge asks me this question, what do you want me to say? And I'll get to where I can share little things. And then it's just a matter of working on our relationship until I can get to a point where they're comfortable letting me say what I feel needs to be said.
Yeah, it's like you're giving them agency, and it's tricky if they don't want it. Okay, another question. The reports you make to the judge create significant changes in people's lives. How are you able to make sure you know the difference between a real case of parental alienation, and I'll put abuse by proxy, versus a false one?
I mean, I think I have the added benefit that a lot of attorneys don't have, which is having prior domestic violence experience and domestic violence training. So I can't speak to how other attorneys do it, but it's a lot of work. It's not just meeting with your client one time. It's having multiple meetings with them. It's knowing what questions to ask them. It's gathering information to help you figure out what's going on with them and what the right questions to ask for. I can never be 100% sure, just like no attorney or judge can be 100% sure. But absolutely, I understand that there are life-changing decisions being made, and that's why I think it's so important that children have representation, because it's their life first and foremost that I think is experiencing the biggest change. So it's doing the work. The answer is it's doing the work. It's not just, unfortunately, like I've seen other AFCs do, meeting my client one time and then never following up with them to see if anything has changed or there's any new information I need to know.
Yeah. Okay, another one, and thank you, Stephanie, for staying on so long with us, but this is a very emotional topic. If the child, I think I already know the answer, but let's see what you say. If the child shares something with you, do you question the parents as well, or do you solely communicate with the judge without asking anything to the parents?
It depends. I will say, and this is my personal belief, and others will do it, will handle it differently. If it's something that I really want an honest answer about what has happened, I may not bring it up before court, because then they have time to think about what their answer is and kind of plan the right thing to say. So if I have a concern, I did this today, I had a really serious concern about a case, and I brought it up in court. I didn't bring it up beforehand, and I think the parent was probably not so happy about that. But I can talk to parents. I have the right to talk to parents if their lawyer consents. Some lawyers will not, and I understand why they would not. So I can't question a parent if their lawyer does not give me permission to. But if they don't have a lawyer, or if I have consent, I can question them. I'm not always going to question them. It really depends on what the issue is. And a lot of times I don't want to give them a heads up that I'm going to bring it up, because I want to see their real honest reaction.
Yeah, that makes a lot of sense. Okay, what is the most rewarding part of your job?
It's being able to speak for kids. Every once in a while in court, I'll have a parent or a parent's attorney say, well, the kid wants this. And that's when I get to chime in and say, no, I am that voice, and here's what they want. Because there are, unfortunately, so many parents who want to dictate what their children want and don't care how they feel and don't care what they think is important. And sometimes it's not things like who they want to live with or how often they want to visit their other parent. I have kids who, all the time, I have kids who say, I just want my parents to stop fighting. And I get to go to court and say, you know what, we wouldn't even be here if you would stop fighting in front of your kid. Or I had a kid who said to me, I feel like I'm not good enough because even when my teachers tell me I'm doing really well in school, my parent doesn't believe it. And then I get to go to court and say, like, you need to hype up your kid. You need to make your kid feel appreciated. And it feels really good being able to do that, because otherwise no one is doing that. No one is being the voice for that kid, and that's a really good feeling. And it's also, this doesn't happen a lot because they're children, but every once in a while we do get like thank you cards, or I got a voicemail from a kid recently saying like, thank you so much for getting the outcome I wanted. And it was rewarding when I had adults do it, but it's a totally different feeling when you have a kid. Thank you.
Yeah, because like I said, with my daughter's own AFC, she changed her life. She really was able to protect her, and you're dealing with much younger clients, so this has a tremendous impact.
Yeah, and yes, and it feels really, really good to know that you made sure that kid's voice was heard, because otherwise it wouldn't have been.
Yeah. So Stephanie, it's going to be on our feed, but how can people find you and see more of your content? And I know you're so good at answering questions, you often turn them into content.
I try, I really do. So I primarily post on TikTok. My username is Steph_NY_law, or you can find me here on Instagram. I'm a little slower on Instagram. I've been posting the videos I post on TikTok to Instagram, but I'm behind, so I have to catch up. But My messages are open on both apps. Lisa's absolutely correct. I really do love answering questions because, I mean, like we've talked about, the legal system is not accessible to everyone. It's not explained to everyone. And I don't think it's fair for people to go through a system having no clue how it works. So I'm happy to answer any questions you have.
Yeah. So thank you so much, Stephanie. It was great seeing you again. I'll be calling on you later to probably talk about this and other things, but you're such an excellent resource.
Thank you. I'm happy to do it. And hopefully I see you outside of here as well.
Yes, we will. All right. Talk later.
All right. Thank you.
Bye. Bye. Thanks again.